The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Please be seated. Good morning, everyone, and welcome to our session this morning. We have 5 cases on our docket this morning. We plan to take a break after the third case for about 10 minutes, but if anything changes, we'll let you know that. And I want to just quickly mention that we have for the first time with us Judge Anne Marie Allen from the District of Utah, who is sitting by appointment, and we are very appreciative of having her with us today. And I also want to mention that this is Judge Federico's first time sitting on the senior side of the bench because of Judge Allen's presence, so big day. But glad to have you all here, and I'll proceed to call the first case, Willey versus Sweetwater County School District, number 1. Case number 258027. Thank you.
Good morning, Your Honors. Mr. Havener, before I begin, Your Honors, I'd like to ask the court, if at all possible, the courtesy of reserving 3 minutes for rebuttal.
Of course.
Thank you.
You'll have to keep track of that, though.
I will.
All right.
May it please the court. Reverse and rebuttal. Reverse the lower court's grant of summary judgment and return this case to that court for further proceedings. That, in fact, is the only proper and just path that can take this court to a proper resolution of this case. How can I say that? I can explain that in one word: Mahmoud. The Supreme Court's decision in Mahmoud v. Taylor last year is a treatise addressing every issue before the court in this case. Justice Alito's decision effectively ends inquiry because Mahmoud is dispositive of every issue before the court today.
Well, we can talk about how it's dispositive on the...
I'm sorry, Your Honor.
I said we can talk about how it's dispositive on the free exercise claims, but would you address how it's dispositive on the due process claim?
I believe, Judge, that with respect to the 14th Amendment due process claim, and bear with me a moment. It clearly acknowledges the supremacy, and I use that word intentionally, of parental rights when it comes to the decision-making regarding the upbringing, health, and welfare of their children. There's no doubt about that. There's no argument. There's 100 years more than that of Supreme Court precedent establishing the supremacy of that act. Certainly, there have been cases where that has been debated, but at the end of the day, Mahmoud is the final piece that was moved to checkmate with respect to that question.
Counsel, on the fundamental right issue in your due process claim, recent cases have discussed the need to narrow that right rather than just speak of it in a general sense. In this case, you mentioned 100 years of precedent that talks about parental rights, but what is sort of the narrowest way you would describe the right that you're invoking?
The right to make decisions regarding your children's health and well-being?
You would just describe it in the general sense? You wouldn't narrow it in any way?
One moment. For starters, Judge, there's no doubt that I believe that the policy at play here places an undue burden on that fundamental right. Here, the district had a clear history of policies that required its personnel throughout the district to withhold any notice or notification to the parents concerning the adoption and use of sex-deviating names and pronouns at the request of the child, and at the request of the child, not to tell the parents. Now, this is not just some minor administrative regulation a school district employee has to follow. There's evidence clearly here that the employees knew the failure to do so would result in discipline, likely termination. Point in fact, the lower court itself acknowledged that. More importantly, if I may, Your Honor, here, the court itself, and I mean the lower court now, acknowledges the importance and ultimately dispositive nature of Mahmoud, referencing that fact in its order granting summary judgment. In a prescient way, I'm sorry, Judge, go ahead.
I wanted to ask also, what conduct are you actually challenging? By that I mean, what specifically did the teachers do or not do that you are raising as being at issue in this appeal to burden your client's rights?
Well, clearly, using alternate names and pronouns, calling their daughter by a male name and male pronouns, and in doing so, in compliance with the district's policy, not telling the parents that that was going on. And in this case in particular, and what's particularly egregious, this is a child, I believe 13 or 14 at the time, who had a qualifying disability under the Rehabilitation Act of 1973. That disability was based on mental health issues. Now, there's no reasonable basis anybody could come to the conclusion that with full knowledge of that disability on the part of the district, that you would not notify a parent of an obvious expression of a mental health disorder, that being gender dysphoria. In point of fact, Your Honors, in every school district in this country, you cannot give a student an ibuprofen or an aspirin without prior written consent by the parent. So,
Talking about,
no, I understand.
we're not talking about that. We're talking about your argument, which I understand to be on the substantive due process claim, that the school had an affirmative duty in this setting to advise the parents, the plaintiffs here, of the choices that their daughter had made. That's what we're talking about. And I don't think Mahmoud supports that aspect of your claim. Mahmoud wasn't about it wasn't a substantive due process claim, and it wasn't about what duty a school has to advise parents of matters affecting their children's well-being. So what authority are you relying on the substantive due process claim?
Well, I think, Your Honor, Mahmoud addresses that not just implicitly, but expressly in dealing with the First Amendment free exercise claim.
Now, I want to know about the substantive due process claim.
Well, I don't think, or at least my position is, Your Honor, you can't simply ignore the dicta with respect to the First Amendment free exercise claim and somehow believe that none of that applies to a substantive due process claim. In the end, the court specifically states that this right, that is the parent's right to raise their child and make decisions regarding the health and well-being of that child, is fundamental. And in speaking with respect to Yoder, which is in fact a 14th Amendment case, they talk about it clearly, that that right is immutable and primary and almost exclusive. The school district was relegated to a subservient status in a reference in the case, and I would suggest that it's tertiary when it comes to those kind of decisions. So they may not have had expressed, I'm sorry, go ahead.
Let me move to the expression claims. Will you tell me how it is that this case is on point with Mahmoud, as you seem to be arguing, and Yoder? There was nothing compelling the students here to participate in any kind of curriculum or policy. There was nothing compelling participation that somehow, as in, for instance, in Mahmoud, where the children were being required to
Attend a class, yes.
in a particular book that they were reviewing, and the parents weren't allowed to opt their child out of that. How does that relate to what's happening here?
Your Honor, I believe that
That the school decided to respect with their policy the students, not just this student, but every student's choice as far as their name preferences and pronoun preferences. This is about the school's policy to respect the student's choice, not about the school imposing some kind of curriculum on their parents.
So for starters, Judge, the court specifically says that coercion is not necessary. It can be much more subtle, and as it was in this case, insidious, quite honestly. Here,
What was the coercion here?
Here,
What was the coercion of the student?
well, it was more subtle and less direct, Judge, but here you have young children at the watershed moment in their lives, 12, 13, 14, 15 years old, being influenced by authority figures who they respect and must follow, not just in the classroom, but in the hallways, in the lunchroom and cafeteria, on the athletic field. So it is a pervasive undermining of the parent's right to make decisions regarding the upbringing of their child and instilling in that child their sincerely held religious beliefs by offering a not just controversial, but frankly, counter ideology and ideas to these children. So it is coercion in a very subtle and manipulative sense. And the court acknowledges in Mahmoud that that type of action violates and burdens a parent's free exercise right. So
I'm understanding correctly, the coercion is the fact that they offer this choice to the student at all?
well, that,
Use a nickname or a different name and a choice to use
well,
certain pronouns. Is that the coercion?
the coercion is, as much as anything else, Judge, the subtle influence on young minds at a fundamental point in their life when they don't have an opportunity to really comprehend what's going from authority figures, number one. Number two, coercion is not necessary in the classic definition of that term. Coercion can be very subtle and almost apparent or non-apparent. So I don't think it's fair to simply say because we didn't require the students to go to a class or read this book, but we did require our staff to call the student by an alternate name, thereby facilitating in a pedagogical setting, as I said, throughout the course of the school day. So I do think Mahmood is dispositive on that issue, Judge, with respect to this. And if the court will allow, I'd like to reserve the rest of my time for rebuttal.
Thank you, yes.
Thank you, Your Honors.
I always feel so short when I get to these things. Good morning, Your Honors. May it please the court, counsel. This, I think, is a relatively straightforward case of just applying summary judgment principles. The defendants in the district court brought a motion for summary judgment saying that the plaintiffs had failed to present evidence in support of their prima facie case. And the court agreed that there was a complete lack of evidence in support of these claims. And therefore summary judgment was entered. And I don't think that it needs to be changed, altered, or otherwise overturned at this level. We still, after a full briefing on this matter, 3 years in, we don't have any evidence that, for example, in the 2020-2021 school year, when the student at issue was allegedly referred to by varying names and/or pronouns, that there was a district policy whatsoever governing those things. It didn't happen under the color of state law. These were teachers who testified that their interest was simply, well, the student asked me to. Or I heard somebody else using that name in the hall and I figured that's what she went by. This isn't a district policy. And in fact, it was never, no policy. There was never a district policy. At best, there was a district procedure. And that distinction is important because a policy has to be adopted by the school board, whereas a procedure is just explaining to staff how they're going to follow a requirement that exists already. It was never the district's requirement in essence. It was a requirement that came down from the President of the United States at the time, issuing executive orders saying, we're going to apply Bostock to issues of gender identity, and you have to comply with that or you lose your Title IX money. So the procedure that was in place was basically just to explain how to comply with that requirement. What we're gonna do is if someone asks you, we're not influencing or coercing anyone. In fact, it's a completely internal procedure that no student ever would have known about. We're not gonna, but if someone asks you and says, hey, I wanna go by a different name or pronoun, honor that. It's as simple as that.
Following school year, which I think is 2022-2023, which is also my understanding the last year the student attended the school, there was a policy in place, and my understanding is the evidence that that policy may have been invoked in relation to this student. The universe of evidence is an email exchange between a former teacher, a middle school teacher, and the student. And first of all, do I have that correct?
Well, that would be a procedure, so not a policy. And I don't believe there was evidence, and in fact, what the lower court found was that plaintiffs/appellants had argued, and frankly strenuously, that communication violated district policy. And so therefore, because that communication was in violation of district policy, it could not be in furtherance of state action.
Well, the email exchange itself, though, starts with the student reaching out to the teacher to talk about, I think, a school board meeting where they were discussing, the policy, procedure, however you want to phrase it, at issue here. So it seems to me that, it's at least relevant to the discussion of that policy. Would you agree with that?
I mean, it is relevant, certainly, and I do think if you read what the teacher says, what he explains to the student is, this doesn't change anything. Nothing's different. We always, it's just telling us what we have to do, what the requirement is, which is we're going to honor student names and pronouns. So there was a discussion of that. I don't know if that portion would be deemed outside of district policy, frankly. It seems pretty straightforward.
Well, what is your view on how that email exchange, because again, my understanding is that's the only potential evidence within that school year. How does that relate to the summary judgment grant and our assessment whether or not there's a genuine issue material fact?
Sure. I think there must be, to show governmental action, there has to be an official municipal policy that guides that action. I don't think there's any reason to believe that that email exchange was in any way guided by an official municipal policy. It was frankly outside of municipal policy and unknown to the district itself. It wasn't, hey, you should email students. No one said, hey, email students about these issues, or respond to a student in a certain way if they email you. It had nothing to do with that. It was simply, the only procedure at issue at that time was if a student asks you to use a different name or pronoun, do it. And that's really all there was to it. There's nothing in that procedure, contrary to what appellants repeatedly say, that required or even suggested that teachers should withhold information from parents or lie to parents or deceive parents. And in fact, as was the case here, the very first time the parents inquired of any teachers, they volunteered the information. Oh, we know your student by a different name.
That duty on the substantive due process claim, what about the idea of an affirmative duty, at least in this instance, to advise parents of a matter that certainly is of interest to the parents, which is essentially their children's choice of identity?
There are any number of...
Are there any cases really that go to that issue that you can point us to, at least at the Supreme Court level?
None, frankly, no. I mean, I think there are cases, certainly, such as, Runyon v. McCrary, that states that parental rights in terms of, educational policy are not absolute. And I think that's especially true, whereas here, what we're talking about is an internal policy. It's not a curricular aspect in any fashion.
Well, it's an internal policy that recognizes a child's choice as to their identity, and does not have any requirement that parents are informed. And I understand you're saying that they encourage a child to inform parents, but in certain circumstances, the parents are not informed, and the child doesn't tell them. And I'm saying, is this something so fundamental that regardless of a child's choice, that it shouldn't be up to the school to determine one way or another what parents should be told, that choices their children make about their identity should be given to parents. They have that right in terms of their upbringing and guiding their upbringing, whether you agree with it or not.
And I think
Do you see what I'm saying?
I do see
Is
what
this
you
distinct from so many other things that, I understand how broad this could get, what impacts their well-being is broad. But we're not just talking about well-being here, we're talking about identity.
I think you just hit the nail on the head in saying that, what a student decides to tell their parents about their identity is between the student and the parents. It's
Not what I'm saying. I'm
it's not-
saying, does the school have an obligation regardless?
No, absolutely not. And if they did, they would be violating the student's fundamental right to, one, exist and their right to free expression. I mean, think back to, say,
Does the student's right always outweigh the parental right regardless?
No, I mean, of course not, no.
Right?
I mean, I would certainly agree. I just don't think that there's an instance here where there's an affirmative duty to go tell a parent, hey, I think your student may be having gender identity issues. One, they're not qualified.
There isn't a may here. This student had asked to be referred to.
By a different name. I don't know that name. One was a
Pronoun.
One was a tree, one was a body of water. Those were the two names the student tried to...
It was pronoun issue, I believe, right?
And I don't know that that's true. I don't think that was ever established.
Right.
And one of the teachers did testify that she might have, but there was no clarity there.
What if it was more certain? What if it was a more certain issue as to gender identity? Does that make any difference?
I don't think so, because part of that would be, I guess the why of it. What we're talking about is, does that violate the appellant's fundamental religious rights in raising their children? And I don't know that the district would have any reason to know what the...
Well, I'm talking now about the fundamental right to parent and raise your child the way you want to raise your child.
Okay. It's not, it's certainly not a medical issue.
And
It's
to
not.
direct your child's upbringing. I'm just asking if
Right.
identity might be something so fundamental, so basic that,
And I just don't think it is, in that, for one, kids try on various hats throughout their teen life. I don't think this is necessarily, someone says, hey, I want to
well,
be.
what I'm saying is it up to the school to make that determination? How serious it is or not serious? Shouldn't the parents be told?
I mean, it seems awfully Orwellian to me to require a school to, upon hearing, hey, the student made some decision about their life, I have to go tell their parent right now. That is.
We're talking about a decision about identity again. I would be asking you the same thing if if the student was identifying as a furry animal, which is, also happens. And
I don't believe
it's
that
not, I mean, it's a real thing. And I don't know that, I assume under this policy, maybe that wouldn't be conveyed either. But I'm saying, is identity so fundamental that parents should know that?
I don't think so. And I don't think that was the law at the time, certainly. I mean, I think this was a requirement that came down from the president, period. I don't think they had an opportunity or a possibility of saying, hey, we're not going to follow that. That was the law. So they honored it. And that was what they were told to do. And I don't think there's any getting around that, whether we, think it's fundamental or not. I don't agree. And I don't think it's, I just don't think it's the school's place to inform on students about virtually anything unless it's illegal, unless it violates the law in some fashion. And this obviously didn't. In fact, it comported with the law. I can't see an affirmative duty there. Because, then where do you stop that? Well, okay, does a parent want to, I'd love to know if my kid is sitting alone at lunch. I'd love to know if he's socializing well. And if you think that's trivial or not.
I'm saying maybe there is a line that can be drawn. I'm asking you, is there a line that can be drawn on issues concerning a child's identity?
And the answer is no. It just isn't. Because it's not different from, anything else that a teenager may decide, oh, I'm lonely, I'm going to kill myself. Wouldn't a parent want to know that? Shouldn't the school have informed them of that? Isn't that a very important issue? That if they see this kid isn't socializing well, or, seem depressed, they seem maybe even, disturbed. I don't know. I mean, is the school necessarily going to have to monitor everything, every bit of a student's behavior? This is an issue where a student, it would only come up if a student asked. And, they have to opt into this to begin with. And there's just no, I think it's a very slippery slope to say there's an affirmative duty on schools on any issue, including identity, to inform on students. It goes too far.
Counsel, with respect to the policy, it would appear to direct district employees to respect privacy in proactively withholding information from parents.
No.
Is that the case?
No, absolutely not. I don't know where you withhold information from parents through respect privacy. I think respect privacy in this context means if a kid says, I want to be called by they, them pronouns, you don't go inquire further into, hey, well, why is that? What's going on in your life? Tell me about your gender identity. Nor would a teacher, have the right upon learning that to, spread the news to other students or staff, et cetera. Oh, this student's queer. That's what respecting their privacy means. It just means, hey, if they tell you, I want to go by different pronouns, you say, okay, and leave it. There's no, hey, withhold that from parents. And, there's no evidence that any parent has ever had that information withheld by the district at any point. So, and, there's testimony from teachers saying, well, we wouldn't have done that, and we don't believe the procedure requires that. So that's the only evidence in the record. There's nothing in that procedure that requires withholding information from a parent. And in fact, in the 2023-24 school year, the procedure was revised to some extent to make that abundantly and explicitly clear.
On the revised procedure, which is the basis of the free exercise claim for Ms. Willey as a teacher, the policy changes, and why doesn't that policy at least invoke concerns that it may not be generally applicable under a Fulton analysis?
Because it's applicable to everyone. That policy or procedure, very explicitly stated, any person, for any reason, can ask for a reasonable accommodation.
Yeah, sure, but then it also says, we'll do our best to accommodate, which sounds to me like it could invite individualized assessment by HR in the school district. Isn't that essentially what Fulton says makes a
Isn't
law
that
or
exactly
policy
what
generally
Groff v. DeJoy requires? A content-specific as an assessment of undue burden? I mean, there's no way that you can do the reasonable accommodation undue burden analysis under Groff that is absolutely required by the Supreme Court under law without having some sense of an individualized exception or exemption. How do you get to the undue burden analysis?
Well, I'm asking about the Fulton cases and general applicability when you look at reasons why an accommodation may be granted. And are those reasons just at the whim of the administrators? Or are there objective criteria? And I just don't see that in this policy, so that's what I'm asking.
Right, there are no objective, there's no criteria at all. If you can't do this, you don't think you can do it, let us know, and we'll do our best to accommodate you. And by do our best, that is the Groff undue burden analysis. That's exactly what it is. They're gonna look, and if there's any way, such as shift swapping, et cetera, they're gonna do it, period, without analyzing the basis or the reasons for your request. So it appears I'm running out of time here, so with that, I would just ask that the court affirm the district court's grant of summary judgment, and I thank you for your time.
Rebuttal?
Thank you, Your Honors. I have barely 2 minutes, so I'll get to the point. With respect to this idea of the policy being generally applicable, nothing's further from the truth. Your Honor, you're correct that this idea that somehow we'll have any reason will be sufficient, that's a canard. Here, it gives complete discretion on a subjective basis based on every employee's asserted problem with the policy or request for an
Indicate that at all, does it? It doesn't indicate that that it can be denied for any reason, an accommodation can be denied. It doesn't say
That's not
anything
what
at
I'm
all
saying.
about
No,
that.
what I'm saying, Judge, it provides a subjective review, individual by individual, and then attendant with that, the discretion to decide, yes, we'll give you an accommodation, or no, we won't.
Policy doesn't even indicate it will be a subjective review. It simply seems to indicate we'll accept your reason and we'll do our best, whatever that means.
Whatever that means.
But it seems to accept the rationale and say, ask for your accommodation, we will do our best to accommodate it, meaning we're going to try to accommodate it, whatever the reason.
It's a convenient trope to allow subjective and individualized decisions regarding a requested accommodation, which clearly takes it now to the level of strict scrutiny, and the policy cannot survive that.
Okay.
Moving on, this idea of not sufficient evidence. This case, there are plenty of instances where we have disputes of material fact. The most glaring and obvious is the 4 teachers who testified. The appellee conveniently ignored Jessica Pulaski in its briefing because she testified that the policy was in fact compulsory and that if she did not follow it, she would be terminated. Now that creates a glaring issue of material fact. I could go on. The chairman of the board stated as much. All right.
Close up.
Well, if I could then, Your Honor, I'd like to leave.
Counsel, can I ask you
I'm
2
sorry.
questions about the scope of the appeal? Is Miss Willey still employed as a teacher at Sweetwater School District?
No, sir, she is not. No, Your Honor, no.
How does that change our assessment whether there's still a live case or controversy before us?
Well, I think you're talking with her First Amendment as a teacher claim, Judge?
Yes.
Yes. Well, I think that's an excellent question, and I don't have an excellent answer for you. However, there were damages that were inflicted on her as a result of her not being provided the accommodation she needed. And then you've got an evidence of a warning letter, et cetera, that, but.
Okay, let me ask you one more about the scope of the appeal. You sued both the school district, but also a list of individual defendants. Final judgment was entered on behalf of all defendants, but in the briefs, I don't see anything that argues about the individual defendants and their liability. Have you forsaken or waived that argument as to the individual defendants?
Well, it depends on what this court does. I believe that that was the wrong decision,
Yeah, but you didn't tell us why in your briefs.
I realize that, Your Honor. I realize that.
Okay.
Yes, Judge.
Any other questions? Your time's up.
Okay.
Thank
if
you.
I'm sorry. If I may, Judge, I'd just like to leave you with an admonition and warning that was given to us by the 35th President of the United States. When a fundamental and articulated right is compromised as to one citizen, the rights of all citizens are threatened. Thank you.
Counsel, we appreciate your arguments. Are excused. On to case number 25-8008, Wyo-Ben versus Burgum.
Good morning, Your Honors. Robert Marsh on behalf of the appellants. With me today at counsel's table is my co-counsel, Mr. William Marsh. May it please the court, this court ruled in its prior opinion in this same case, and I quote, "For placer claims like Wyo-Ben's, the relevant statute, 30 U.S.C. Section 35, requires the applicant to tender payment of the purchase price. And as if that weren't enough, the respondents admitted as much in oral argument in the district court when Ms. Peters said, publication happens and then final proofs are provided to the BLM office along with a tender of the purchase price. It's undisputed in the record, Your Honors, that Wyo-Ben did exactly that on August 30 of 1993 when it delivered a check for the full purchase price for its claims to the BLM state office in Wyoming, exactly as this court ruled was its statutory obligation under the statutes selected by Congress as defining the bounds of Wyo-Ben's entitlement to further processing, notwithstanding the patenting moratorium.
But counsel, timing matters, doesn't it? I mean, just the tendering of payment alone, depending on where you are on the process. I mean, isn't that really the merits question before us? I mean, this sounds to me like you mailing in an application to a university and sending a check and saying, well, I paid you, so you have to admit me now. Why isn't this different?
It's different, Your Honor, because Congress has said so. What Congress selected as defining the applicant's entitlement to further processing is 5 specific statutes from the general mining law. What those statutes require is that the applicant tender payment of the purchase price. And the timing question, Your Honor, is addressing is really answered by when are the final proofs submitted. That is answered in the regulations and in the law that Congress selected, as well as once the final proofs are submitted and publication has ended without an adverse claim being submitted, then the applicant has both the right under the regulations and the obligation under the statute to tender the purchase price. In that case, that's exactly what happened. Publication ended without an adverse claim. Wyo-Ben tendered its final proofs as it was obligated to do and tendered the purchase price. At that moment, Wyo-Ben had done everything that it could do and that was required by the statutes Congress selected as defining its entitlement to complete its application. It's also worth note, Your Honors, that the merits of Wyo-Ben's claim are really uncontested. In respondent's brief on the merits in the district court, respondents have admitted that the 1997 review of Wyo-Ben's application, that is their current iteration of "we've already done this," they have admitted that that review was not done on the basis of only Wyo-Ben's actions to comply with the general mining law, as this court has repeatedly ordered is the standard.
Can I get you to back up? I'm confused, honestly, as to why we are here. The last appeal, Judge Holmes and the panel repeated over and over and over again that the only reason your 30-year-plus claim was timely was because you were alleging agency inaction, and that was what the panel decided was a repeated violation, not a continuing violation, but a repeated violation. It said it over and over and over again. This is an agency inaction claim. Now, we go back, and the district court said, what turns out, yes, the secretary did act, and they acted through BLM, and they acted lawfully through BLM. We come back now on appeal, and you say, we're not challenging, it's not even, it's moot whether the agency, in your footnote 17, you say the delegation issue is moot, regardless of whether BLM or the secretary had authority to issue, because no one within the Department of the Secretary on down ever has the authority to disobey a congressional command. You have completely switched now, and we're no longer talking about inaction, as far as I can tell, which was the only basis for this case still being alive after all these years, is that the agency had failed to act. And now that's not even seeming to be where you're at anymore.
So I disagree, Your Honor.
Say it doesn't really matter.
What doesn't matter is,
Secretary acted. How does that not just end this case, as the appellees essentially argue?
it's because
If you weren't arguing agency inaction.
it's for a couple of reasons, Your Honor. So number one is what is moot is whether the BLM was entitled to act. And it's moot precisely because
Well,
they
you
have-
say in the footnote, it doesn't matter who acted. Doesn't matter whether the secretary had authority or acted. What
because,
happened here?
because they haven't done what Congress ordered, and they have admitted it. So as I phrased it to the district court, you cannot say
You're
you've done.
complaining now about what they did do, not about what they failed to do.
No, Your Honor, we are saying they have failed to do what they were ordered by Congress and this court to do, which is to review Wyo-Ben's application and determine its qualification by reference only to Wyo-Ben's actions. It is undisputed they have never done that because in their
That's
own.
that's a new theory as far as I can tell. Previously, it was the secretary had never acted.
And the secretary has still never acted, whether by delegation or
Hey, that
individually.
doesn't make any difference.
What we are saying is it doesn't matter whether the secretary,
Got here. That's the reason your claim was timely.
and it has always been, as exactly as alleged in paragraph 25 of Wyo-Ben's complaint, the gravamen of this case is neither the secretary nor any of the secretary's subordinates has ever done what Congress ordered, which was to review Wyo-Ben's application based only on Wyo-Ben's actions. What they did, which is not what Congress ordered, is to review it based on their own
Complaining about what they
inaction.
did. You're complaining about what they did, which
respect.
is not inaction. And the court made that very clear, the distinction between inaction and action in the prior appeal.
Respectfully, Your Honor, what we are complaining about is that they have never done what Congress instructed and Mount Emmons.
You're saying they did something, but you don't think they did the right thing. That's different than saying they did nothing.
Correct.
And getting here because it's timely, because you said they never acted.
It's undisputed that they have never done what Congress ordered, Your Honor. It's,
Court case law that says in an APA 706-1 claim, which is what we have here, that if there is inaction, the court's remedy is just to say, take action. You don't tell them how to do it, which is kind of what I hear you saying. They've never taken action as Congress directed. That would be this court saying, you must do it, take some action and do it in this manner. Why wouldn't that remedy that you're seeking run afoul of Supreme Court precedent?
Because there is no discretion left, Your Honor. Over 30 years, the respondents have never once identified anything in Wyo-Ben's application that was incomplete, that would require them to redo any part of the process. As a consequence, they've either waived or forfeited those arguments before this court today. All that is left is the issue of whether Wyo-Ben appropriately tendered the purchase price. And as I said, it is undisputed that it did so in complete accordance with the law and the statutes that Congress selected as the dispositive
I feel like
issue.
we're asking the same question, maybe repeatedly, but do you dispute that they made a determination at all about Wyo-Ben's application?
No. The point is that none of those determinations were bounded by.
Lawful, they didn't follow the statute, but you agree at least that by not including Wyo-Ben's application as an exception to the moratorium, and then I think it was in an instructional memorandum, that they at least made a decision on it, right?
Yes, they did something, but they still have yet to do what Congress and the 10th Circuit
And
told them they
that's
had
contrary
to
to the argument you made to this court in order to come within the statute of limitations.
do. Respectfully, no, Your Honor. The argument has always been they didn't do what they were instructed to do. It has never been that they did nothing. It's that they have yet to do what
Well,
they were
that's what this court
required
found,
to do.
is that there had been inaction, and that's how you got here.
Yes, and if anything has,
We misunderstood your argument back then?
no. If anything has changed, Your Honor, what changed is 3 years later, and after this court's prior determination in this case, the government disclosed some new documents. That's where the 1997 instruction memorandum came from. And it remains to this moment undisputed that that action, that determination, that review was based on the status of processing by the BLM. And this court in the Mount Emmons case said, the Secretary's action is contrary to the moratorium, quote, because the Secretary bases the applicant's eligibility for exemption on how far the Secretary has processed the application. While, quote, the moratorium clearly and unequivocally bases the applicant's eligibility only on the applicant's actions. And so, as it was 6 years ago, as it remains today, the issue here is inaction. The respondents have never done what Congress has ordered them to do 36 times.
Let me ask a similar question in a slightly different way. In your petition, the relief you seek is an order requiring the defendants to review the application to determine whether it qualifies for the Section 404B exemption to the temporary moratorium. Have they not already done this?
Not in accordance with the criteria for that determination that Congress instructed, Your Honor. They have never applied the criteria that Congress selected, which is Wyo-Ben's actions, to comply with the statute. And with Your Honor's permission, I'll...
And that is not that does not qualify, what you just said does not qualify as a 5 U.S.C. 7061 unlawfully withholding agency action. That is complaining about the action the agency took and the reasons it took it. It is not a 7061, which is what we said the last time around it needed to be in order to come within the statute of limitations.
Respectfully, Your Honor, it is exactly what Mount Emmons said was a 7061 action subject to remedy under the APA. But with Your Honor's permission, I'll reserve my remaining time.
Good morning. May it please the court, counsel. My name is Jasmine Peters, and I'm an Assistant United States Attorney in the District of Wyoming, representing respondents, appellees in this action. The reason why Wyo-Ben is not entitled to relief under APA Section 706(1) can be distilled down to 3 reasons. The first is that Wyo-Ben no longer argues agency inaction. It argues action, which is under 706(2). And that is the argument that is properly before the court. Aside from that, though, 2 other reasons exist. One is that BLM acted in 1993 on its patent application, then again in 1994, and again in 1997. And then finally, the notion that there is an unconditional right to tender payment is, one, not properly before this court, but aside from that, is unsupported by the mining law of 1872, regulations, and policy. While considering all of these points, as we go through this morning, context matters. What was happening in the patenting world in 1970 to 1994, before the moratorium came into effect, sheds light on both Wyo-Ben's actions and BLM's actions. There was no dispute that at this point in time, when the moratorium was coming into effect, that everyone, applicants and staff at BLM, understood that patenting was coming to an end. The 5-year plan, which is in the record, demonstrates that history for the court and does a good job at synthesizing what was going on. Now, Wyo-Ben initially brought this case under a 706(1) claim. 706(1) is asserted when the agency failed to take a discrete agency action it is required to take. In the brief before the district court, it even acknowledged that the sole issue now before the court is whether the secretary must decide whether the application qualifies, referring to the exemption under the moratorium. Wyo-Ben also initially argued that BLM lacked authority to act. But in Wyo-Ben's opening brief to this court in footnote 7, it referred to those issues as moot. It also referred in footnote 1 of the reply as irrelevant and argued the same in the district court. But whether BLM had the authority to take action and whether it did take that action on Wyo-Ben's 1993 application is precisely the issue that was before the court and that was previously argued. But as this court knows, a failure to act is not the same thing as a denial.
Stop you 1 sec. You just said a moment ago that Wyo-Ben originally brought this action as a 706(1). Isn't it still a 706(1) as we appear in court today?
On its face, that is why we're here. However, when we're looking at the actual arguments, they are arguing agency action. Whether you call it 706(1) or not, we have to look to what is actually being argued. And it matters.
But what about the fact that we're only here because the prior panel called it a 706(1) and said that's why it's not barred? Time-wise. And we wouldn't be here if that hadn't happened.
You're correct. In 2023, this court previously held that the statute of limitations argument that was raised under 2401, the 6-year statute of limitations, did not apply specifically to a 706(1) argument because the repeated violations doctrine applied. That is different. The arguments have shifted since that time. So now what is happening is we're still under the premise of a 706(1) claim while Wyo-Ben is arguing agency action, which is not properly before the court.
Well, shouldn't that cause us to reconsider the statute of limitations issue?
Yes, if the court understands that Wyo-Ben's argument has morphed into a 706(2) claim, the respondent's appellees argue that it is barred by the statute of limitations.
And how can we allow it to morph when we've already said, based on what they said it was, it's timely, but had they said it was what it is now, what it's morphed into, it would not have been timely. it seems like a runaround around our prior opinion. And you get it in there and you find out, okay, we're okay, we can bring this, and then you change your approach. Or you keep your approach, but I don't know. I'm confused as to what we do with our prior opinion for saying this case was timely to begin with.
So based on what Wyo-Ben has argued and what it has argued since that opinion, when 706-1, that claim first came, Wyo-Ben was arguing that the secretary never acted.
Right.
It also argued that BLM never had the authority to act. But since then, it has waived that argument. It has changed course after the remand. So the remand
Well,
order...
you don't get to change course when you're only there. I thought that was your position in your response brief, is we should not even consider the merits of this because you don't get to change course when that was the basis for finding the action was timely to begin with.
Your Honor, you are correct. And I
I'm
apologize.
confused as to why you're not asserting that today.
I am asserting that.
Okay.
I am asserting that this case is only properly reviewed under a 706-1 claim. However, the district court did go into a 706-2 analysis. And because of that, we have to
Pay attention to that.
Your Honor, I don't think you need to. I think this case can be properly resolved under 706-1. In fact, by Wyo-Ben's own admissions, that BLM did act and it did have authority. There is no dispute on that. But if the court wanted to look into the issues that were reviewed by the district court and argued by Wyo-Ben, the untimely claims,
Statute of limitations.
they are. But even if you wanted to look at them, the record in this case is quite clear that BLM acted, and it acted with proper delegated authority. And even if you considered a 706-2 claim, which is not properly before this court, you can still find that it is in accordance with the law based on the regulations, the mining law, and policy. And so those are the arguments before this court. Primarily, the 706-1 claim that is properly before this court should be the answer to this court's ability to affirm the judgment.
Counsel, can I just make sure on the timeline that I understand when the morph occurred? So this case is before this court. The panel opinion, as we've been discussing, calls it a 706-1 action, discusses statute of limitations, and you said the morph happened when it went back on a remand before the district court. Was it there and before the district court that Wyo-Ben then repackaged a 706-1 into a 706-2 argument? Because even as I look at the opening brief, they don't even mention 706-2, which I think you pointed out in your response brief. So did they sort of change horses mid-race before the district court, or did that not happen until the reply brief here maybe?
When I review this case and I looked at Wyo-Ben's arguments, it seems as though once IM 97-165 came to light in accordance with Wyo-Ben's opinion, it came to light, that's when the arguments shifted to argue that IM is no longer in accordance with law, and so therefore there was no action, which is an argument we dispute. Those arguments did change from agency inaction to action without explicitly saying so. But as the record shows, IM 97-165 was an instructional memorandum that came into effect after Mount Emmons. This was not a memorandum that was hidden to Wyo-Ben. Wyo-Ben knew of this memorandum. It knew of the action that was being taken. And in fact, one of the applications that was allowed to proceed under Mount Emmons and that memorandum was Richard K. Brown, an affiliate of Wyo-Ben. And so to claim that IM 97-165 was somehow just brought into the court at a later date is not correct. It's a public document. It was well known.
Well, even if it was, the response, you don't just morph into a new argument. You seek to amend your complaint. You do something, but you don't change your argument.
And presumably, Wyo-Ben understands this and is why it hasn't argued a 706-2 claim, because it is statutorily barred. There's no question about it. And so I think that is why we're here today, continuing to argue a 706-1 claim under interesting and convoluted arguments that have really hinged on agency action. And Mount Emmons is different than this case. Same with Vanderbilt. When we look at the cases that came before this one, those cases were different in many respects, specifically the factual differences, but more so in those cases, the applicants were not arguing that their application hadn't been decided whether or not it was subject to a moratorium. In Mount Emmons, the whole issue was whether the physical location of the application under IM 9501 was in accordance with the law, and that court did look at 706.2 and 706.1, at least from the order that has been published. That's what we see. But throughout the record, if this court wanted to dive into whether or not the BLM took action, it clearly did, and Wyo-Ben does not argue to the contrary. Where you can see that most specifically is on August, I believe, 31st, 1993, there was a correspondence exchange between the parties. At that point in time, that's when Wyo-Ben had attempted to submit payment, which again, was premature. It wasn't asked for, called for by the BLM office. And that was a determination made in 1993, well before the moratorium came into effect. And so this notion that Wyo-Ben had an unconditional right to tender payment is not supported by the regulations, the mining law of 1872, or policy. And we can see that most specifically when we look to the regulation on payment of the purchase price, 43 CFR 3862.4-6. In that regulation, it specifically says that the authorized officer referring to the appropriate BLM office will, if no other objection appears, so to determine whether an objection appears, you have to review it, will permit the applicant to pay. By its own language, it is clear that the authorized officer is the one to grant permission for payment. And so when we take all of this together, the court should affirm the district court on its determination that Wyo-Ben failed to bring a 706.1 claim because the BLM did act on its application and acted with undisputed delegated authority. And aside from that, if the court has any other questions, the respondents' appellees respectfully request that it affirm the judgment in this case.
Thank you. Thank you. Rebuttal?
May it please the court, like most other issues in this case, the controlling decision here is this court's decision in Mount Emmons. In that case, the respondents had done exactly what they have now revealed to us they did to Wyo-Ben. They accepted an application, they received the purchase money, and then they issued an instruction memorandum that says, we don't have to process this any further. That is exactly what happened here. And the Mount Emmons court looked at those facts, which notably are not that the respondents had done nothing, but that what they had done is not what they were ordered to do, because they had misapplied the criteria established by Congress. And on that basis, the Mount Emmons court found that the respondents had unlawfully withheld administrative action required by a clear and unequivocal act of Congress. That's exactly what has happened here, and it's exactly the same in action. A simple analogy: if Congress ordered the Department of the Interior to go paint a fence white, and the Department of the Interior went out and painted a garage red, they could not say that they had done what Congress ordered. And the failure to do that is the inaction under Section 706.1. I would also like to mention that Ms. Peters' argument about Wyo-Ben had no right or obligation to tender this is contradicted by the respondent's own regulations at 43 Code of Federal Regulations 3862.6-1, which establishes that obligation. but my time is up unless your honors have any other questions.
Much appreciate it.
Thank you, your honors.
It's counsel, the case will be submitted and counsel are excused. We'll proceed with case number 25-8021, Cubin v. Gordon. Counsel?
Good morning, Brendan Philbin on behalf of the appellant, Dr. Eric Cubin. And just like to ask to reserve 3 minutes in rebuttal. And may it please the court, in February of 2024, Dr. Eric Cubin exercised that sacred right that we hold as Americans by participating in a representative government, by advocating for legislation under consideration at the Wyoming House of Representatives. For doing so, Governor Gordon removed Dr. Cubin from the Wyoming Medical Board in violation of his First Amendment rights. In analyzing this case, the district court erred in 2 specific areas. First, Dr. Cubin's email was on a matter of public concern, specifically the debate in the Wyoming legislature about Chloe's Law. Secondly, the district court conducted the Pickering balancing test prematurely and found, without evidence and based on pure speculation, that Dr. Cubin's email would disrupt operation of the medical board.
About a matter of public concern, in our mixed speech cases, what would you say is a discernible line between how much of the speech can be about a matter that may be of public concern versus a private grievance?
Thank you, Your Honor. I would point this court to Moore v. Winwood, where in that case, the speaker, while holding some personal animus towards a fellow officer, used that as to provide perspective to the debate in that case that was in front of City Council regarding a police-involved shooting. And so here, and what the court failed to do is to consider the context of Dr. Cubin's speech. And to provide this court with that context, the Wyoming Medical Society advocates and lobbies for physicians in the state of Wyoming. So the Wyoming legislature typically hears from them on all sorts of bills that are in front of them. And because they were not hearing from what the Wyoming Medical Society purported to do, is to represent all doctors, Dr. Cubin felt the need to advocate in his own behalf, which is the quote he used in the email. And advocacy generally entails talking about your opponent, maybe poking holes in their argument, highlighting their weaknesses and biases. So if we take the whole email that Dr. Cubin wrote, first, he's explaining to the legislature why the opposing position is wrong, because it was biased and infected with some political, ideological concerns. And if we take the whole email and we look at it, we can see he provides specific examples of why he believes the bill is a good bill and why it should pass, mainly in Appellate 31, the last half of that. And after he sets up his opponent, he says, I feel the need to advocate on my own behalf by coming to you directly with this information. So he was not airing personal grievance or in employment context like in Connick and other cases like McAvoy in the circuit. He was advocating, and part of advocating is talking about your opponent and why they're wrong and why they're weak. So to
Well,
that,
ultimately, sorry, I apologize. Excuse me. Ultimately, his grievance seemed to be what was going on the inside of the medical association, right? I mean, what was happening there and how they came to make or take a position on Chloe's law. And he was very unhappy with the position taken, and he was unhappy with leadership for taking that position. That seems clear from his email. But why is it ever a matter of public concern when members, because essentially he's speaking as a member of this association now. I mean, he's a private citizen, but he's saying, I have this information because I'm a member of this professional association, and I don't like what is happening in this association or how they made their recommendation. And I understand he's concerned about that, but what makes that a matter of public concern any more than any membership in any professional association, which I don't think there is an association out there in any profession where there isn't strong feelings about positions taken by the association, and yet it happens. And there's angry members, and yet it happens. But why is that internal dispute, which is understandable and happens, and he has a right to be unhappy about it, but why is that a matter of public concern?
because it is relevant to the advocacy and the debate, because the Wyoming Medical Society is purporting to represent physicians in Wyoming that are members.
And they have a right to do that,
And they do.
right? The members have given him that right.
Right. And however, if members do not feel that they are being advocated for properly, they should feel free to
They're free to go forward,
to go and speak.
what he's done.
Yes.
But that doesn't make his concern about what's happening within the membership or how the membership arrived at its position that it took a matter of public concern. Do you see what I'm saying? Because that's what you're saying is the matter of public concern, that everybody out there needs to know how this association arrived at it and that there's members that don't agree, which would be every case ever in a professional association that's providing information or a recommendation to a legislative body
Your Honor,
who don't agree.
you're right. Your Honor, it's our position that Dr. Cubin spoke on a matter of public concern, and that public concern was the debate surrounding Chloe's law. And I fear that.
Okay, I'm misunderstanding then, because
Oh,
I
I'm
thought
sorry.
he was trying to advise the legislature that they should be concerned about the medical association's recommendation and the basis for it.
No, Your Honor, the purpose of his email, taken in the whole, I would point to Appellate Record 31. This, from the perspective of a Wyoming doctor who practices medicine at the hospital he was born, I can tell you that this is a very good bill. I want to advocate on my own behalf
Right.
for this bill. And 2 paragraphs up, he talks about why he feels it is a good bill and should be passed. And in doing so, he is adding context and speaking about the other side. And I fear that if we read this email too narrowly,
It's about
then
the other side. He's talking about his concerns about his organization, his private organization that he's in.
and the opinions that they hold, which are opposite to his. And I fear that if we read this email too narrowly, then we will chill the First Amendment ability in a way that dictates how people can advocate. Because if we say that you can't talk about your opponent and their position,
He can talk about it. That's not our issue right now. The issue is whether this is a matter, what he was talking about, his private, interest or matters of public concern.
Dr. Cubin, it's
What part of his email makes it a matter of public concern? My understanding was you were suggesting it was the part where he discusses the association.
no, the public concern in his email is advocating for the passage of Chloe's Law, which the bulk of that advocacy occurs in the final 5 paragraphs of his email on Appellate Record 31. He's arguing the merits of the bill and why it should pass, and that is the public concern.
Private view about the bill is what you're saying.
Yes, yes, Your Honor. He is speaking in his private capacity, not as a member of a board. He sent this from his personal email. Board members have no reason to communicate with the Wyoming House of Representatives, and he says, I'm writing from as a perspective of a Wyoming doctor, not as a sitting board member.
He says he's concerned that the Wyoming Medical Society's inaccurate statements to the state's lawmaking body could impact all Wyomingites. I don't know if I said that right. So to me, it's pretty clear that what he's complaining about is the internal working of the society. And the question is that a matter of public concern?
I respectfully disagree with the reading of that, and his purpose in writing that statement is to try to cut down the weight that the Wyoming Medical Society holds in this public debate on this legislation. Because the Wyoming Medical Society, again, purports to speak for the doctors of Wyoming.
It's your suggestion.
That's a heavy
You would be
credit.
saying that's a question of fact as to what that meant, is what you're saying, right?
Yes,
That we can't be deciding at this point, and
yes,
I
yes.
assume that's your position, yeah.
Yes.
It certainly could be taken a different way,
Yes.
Is the preliminary injunction denial now moot because final judgment has been entered?
Yes, it's moot. We concede that point. If I may move to discuss the third prong of that Pickering balancing test, where the government's right to speak, or the government's interest in efficient operations is balanced against the public employee's right to speak. And it's because that has to be shown with evidence and not pure speculation. And it's because of that evidentiary standard that Your Honor wrote last January in Brown v. City of Tulsa that the application of the Pickering balancing test will be possible only after the parties have had an opportunity to conduct some discovery. So the district court here, like the district court in Brown, in granting here the motion to, on the pleadings and there the motion to dismiss, it erred by jumping the gun on conducting the balancing test before the parties proceeded to discovery. And the result of that lay bare. The speculation about the impact of this on the board starts at the genesis of this case. If you read the governor's letter on Appellant 33, I believe your comments on the particular legislation could give doctors a reason to believe that there's bias. So that speculative language has persisted to this very moment. And the state and the governor has not provided any evidence to support that speculation that he opened this matter with. And I note that I'm going into my rebuttal time, so sit down. Thanks.
Counsel?
May it please the court, counsel. My name is Jim Peters, and I'm here today on behalf of Governor Mark Gordon in this matter. This case involves the governor's authority to remove a licensing board member when the governor determines that statements that particular member has made can compromise that member's ability to perform his duties on that particular licensing board without the appearance of bias. And I'd like to focus first off on the third element of the Garcetti-Pickering test, and that's whether the government's interests as an employer outweigh the employee's free speech rights. So looking at this case, it's whether the government had an adequate justification for treating the employee differently than other members of the public. So we look at whether statements made by particular members would impede their ability to perform their duties or interfere with the agents or the operations of the agency. What we have here as a state's interest asserted by the governor. That interest is ensuring that licensing board members in Wyoming, in particular on the Board of Medicine, are able to perform their duties without the appearance of bias.
I might stop you though and ask you, isn't the real question before us the procedural sequence of this Pickering balancing as and when it's employed? As counsel noted, this court has said at the motion for either 12B6 or judgment on the pleadings here that it's generally improper to do Pickering balancing because to do that balance, you need evidence. And you may have that evidence, and it may be marshaled at some date before the district court, but why should we deviate from our precedent to say, in this case, that Pickering balancing was appropriate at this stage of the procedural history of the case?
Your Honor, in Moore, this court said that we need not justify predictions with formal evidentiary showing, and we do have that evidence in this case, Your Honor. It's the email from Dr. Cubin. What we have is an email from a member of the Board of Medicine who was sent, but the email was sent in his individual capacity, that is criticizing the leadership of the Wyoming Medical Society, a specific doctor, and it can even be interpreted further to be criticizing any member on the left side of the partisan divide. Really, that email contains charged allegations that not only that the medical society had a position that was contrary to Dr. Cubin, but it contained allegations that the leadership, and Dr. Sanderson specifically, ignored and suppressed evidence and information when presenting its position to the Wyoming legislature.
So Pickering balancing, as the second word implies, is a balance between competing interests. And so in referencing the email that Dr. Cubin sent, it may be then that's a value to determine what his individual rights are and to engage in that speech, but also it could form the basis for the other side of the scale, which is disruption. And that's the part where typically it's difficult for a court to assess until there is, again, a marshaling of evidence. And when I look at this case, as I understand it, the plaintiffs attached to the complaint both the email and the letter from the governor, so that is fair game for us to consider. Is Governor Gordon's email response enough evidence for us to look at a Pickering balancing in terms of weighing what the disruption could be based upon the email that he sent?
Your Honor, I believe that it is, and I believe the district court correctly looked at the complaint and those documents attached to its complaint when it conducted this balancing test. And it looked at, as it relates to the governor's interest and the state's interest as a whole, is looking at the text of that email and those politically charged allegations against leadership and specific members, whether it was reasonable, whether there was a reasonable prediction that Dr. Cubin could not be impartial in certain matters that would appear before the Board of Medicine. Specifically, the Board of Medicine is charged with regulating the practice of medicine in Wyoming, and that includes, adopting rules to implement the practice, issuing advisory opinions, and very importantly, issuing licenses, investigation, and possibly taking disciplinary action against licensees who may come before that. The leadership of the Wyoming Board of Medicine, the Wyoming Medical Society, are practitioners who are regulated by the Board of Medicine. Dr. Sanderson, who Dr. Cubin lofted these allegations against, is a practitioner that's related by the Board of Medicine. It's not unreasonable, based on the text of the email, for the governor to conclude that should there be a matter with Dr. Sanderson before the board or any of the members of the Wyoming Medical Society leadership, that Dr. Cubin may not be able to be impartial in performing his board duties if those matters come up. And Your Honor, that reasonable prediction is important here. As this court is aware, the court has drawn a line between whether specific evidence is required or not, and sort of looks at timing of the action by the employer, determining whether it falls into the long after category or the soon after category. And this court has said that long after, if the action is taken long after, you must prove actual disruptions based on the speech. The timeframes by which this court has found an employment action to be long after, 6 months in the case of the Duda case. But looking at soon after, in the Duchesne case, this court has held that 1 month after fell under the soon after category. And looking at the time frame between Dr. Cubin's email and Governor Gordon's removal letter, it was approximately a little bit less than 2 months. There's no evidence in the record of when Governor Gordon became aware of the email. His letter simply says, I have become aware of this email and I'm taking action now. But
Wouldn't evidence like that maybe be something you'd need some discovery on in order to do this balancing test?
Your Honor, I don't believe so. I think even for purposes of the allegation, I think we can look at the time frame between the email and Governor Gordon's decision, which is approximately less than 2 months, and analyze it under that consideration, just as the district court did. Looking at that time frame, the district court said the time frame slightly less than 2 months is much more similar to the 1 month time frame that this court has held to be soon after, rather than the 6 month time frame, which
Somewhere
is,
in that continuum, and to me, it just kind of points to this whole issue that Judge Federico has been speaking with you about, is it really appropriate at a motion to dismiss stage to conduct this balancing test when there could be additional evidence that might, be relevant to that test?
Your Honor, we do believe that a motion for judgment on the pleadings was appropriate here, and as this court's aware, it applies the same standard as a motion to dismiss under 12b-6. And so we're looking at the factual allegations in the complaint. But not only did the district court consider just the temporal length of time between the email and the action, the district court even went a little bit further and importantly, looked at the nature of the employment with Dr. Cubin's position on the Board of Medicine. Unlike a traditional employment where employees are going to work on maybe an 8 to 5 basis or on a regular basis, the Board of Medicine, these are citizen-appointed members on a part-time basis to perform their board duties. In this case, the opportunity for disruption was much more sporadic than in a traditional employer-employee context where the supervisor and employee might be performing their duties on a daily basis or multiple days per week. That's simply not the case here. And so not only did the district court properly look at the time frame in concluding that it was soon after, but it looked at sort of the nature of the employment, which differs from many of the other cases in which this court has considered whether the action was long after or soon after.
Ask you about that. So how, as a practical matter, do we know what the nature of the employment is with the very limited record that we have?
Your Honor, the Board of Medicine is a statutorily created entity, and the requirements to hold meetings are set by statute and by the board's
And I'm
rules.
aware of the statutes that bear on that, but as a practical matter, how it actually plays out, what the actual functioning is of the board and this particular doctor's role on the board. How do we understand the details of that to the degree that we would need to conduct the balancing?
Your Honor, for purposes of long after, soon after, I don't think that was something that was needed to be considered. But I think that is an additional consideration that the district court put forth based on the statutes and rules governing the Board of Medicine and considered in its analysis. And I think the district court could have simply looked at the time frame between the action, the email and the action. But I think the district court even went further to look at those duties to determine whether Governor Gordon's prediction of disruption was reasonable or not. Your Honor.
It's a public concern analysis.
Absolutely. Your Honor, I think you mentioned it at the outset, but really what we have here is an email that raises a number of issues. And importantly, Governor Gordon's removal action was not based on Dr. Cubin's advocacy for or against a particular piece of legislation. It was based on those comments that were made related to the Wyoming Medical Society leadership and specific practitioners that are governed by the Board of Medicine. Looking at this court's cases on point, courts construe public concern very narrowly. And really, the Wyoming Medical Society is not a governmental entity. So there's no allegation or argument that consistent with this court's cases that Dr. Cubin was intending to expose official impropriety, because those cases all relate to governmental entities.
Clearly not, but he is suggesting that he's exposing private associations' impropriety or their internal concerns, I guess, to the legislature, who are public officials who have received a recommendation from this, or a position statement from this private organization.
Absolutely, Your Honor. And I believe that communication, as you mentioned earlier, is really airing of a grievance related to Dr. Cubin's dispute of how the internal operations of the Wyoming Medical Society exist.
Well, does it make a difference that he's trying to tell the legislature, you need to know this, because if you're, the Wyoming Medical Society has a lot of respect, I presume, and he knows that the legislature respects their position, presumably, and so he's saying, you need to know what's behind the scenes before you act, essentially.
Your Honor, I don't believe that rises to the level of a public concern based on this court's precedent. Well, that's certain.
As a matter of law?
Yes, Your Honor. As this court has said before, matters of public concern are matters of specific importance to the community. While Dr. Cubin's frustrations with the internal policies and procedures of the Wyoming Medical Society may be important to members of the Wyoming Medical Society, it certainly doesn't rise to the level of a public concern that would be important to the community as a whole.
Would it be possible that there could be an allegation, though, of something more significant, fraud or some sort of, criminal activity, something that would perhaps make a private association's internal workings a matter of public concern?
Your Honor, I have a hard time envisioning a scenario that would rise to the level of public concern when a dispute or a grievance relates solely to the internal workings of a private organization, which Dr. Cubin has recognized. The Wyoming Medical Society is a private organization. There has been no allegation that it's a public organization or any public function of that organization. Your Honor, I see my time is up, and so if there are no further questions, I'd respectfully request that this court affirm the district court's decision and that that Governor Gordon did not violate Dr. Cubin's constitutionally protected rights in removal. Thank you.
Thank you, Your Honor. Just to the governor's point about this analysis of when this happened, short after or long after, just want to remind the court that whether it happened short after or long after does not relieve the burden of the government to show that inefficiency would be created by the speech. And to the point that public concern is importance to the community, Chloe's Law in the debate at the Wyoming House of Representatives is vital to the community and vital to our representative government. So
But he was terminated, or he was terminated from the board, not because of his comments about Chloe's Law, but because of his comments about the association and certain doctors within that.
It's our position that he was terminated for speaking on the public concern of Chloe's Law. And the Wyoming Medical Society's position on Chloe's Law is certainly wrapped up in that debate, but his primary purpose in writing the email to the legislature and the governor's reasons for firing him based on the very limited record we have is that he was fired for speaking on that matter of public concern. And
See, though, that if that was the purpose of his letter, to reveal the inner workings of the association and his concerns about it, that that would not have been a matter of public concern?
if he was writing solely about the Wyoming Medical Society, then we would have a question of whether it is a public concern or not. But again, in advocating for any position, it's best to address your opponent's position and what they stand for and why their position may be weak or polluted by whatever. And in the course of speaking on a public concern of the law and advocating for that, he addressed the issues with the opponent, who does carry heavy weight with the Wyoming legislature. This is the lobbying body for Wyoming physicians, and they're coming in with all that weight to support this bill. And Dr. Cubin is speaking to that. So with that, in accordance with this court's decision in Brown v. City of Tulsa, we ask that this court vacate and remand this matter to the district court. And I thank this court for your time.
Thank you both, counsel, and the case will be submitted, and counsel are excused. Thank you. We'll take about a 10-minute break. Come back about 10:46 or so. How about that?
Court is in recess for 10 minutes.
I guess from my side, I see you again. I see, I started on the, all that other stuff and took it over. That's your thought. You did too, you came out yourself, yeah. Yeah. Right. Yeah. Yeah, so, yeah, this is, yeah, this.
Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Please be seated. Call case number 258024, 4B Properties versus the Nature Conservancy.
Good morning, Your Honors. Carolyn Gerlin, and together with my co-counsel Lauren Pappenhausen, on behalf of 4B Properties and Gary Benning, we ask you to reverse the district court's grant of summary judgment in this case. This is a case with a long procedural history and a dense fact background, but in the context of the district court's grant of summary judgment, the operative facts and legal standard are straightforward. Two witnesses, Mr. Benning and his now wife, Mrs. Benning, provided consistent sworn testimony about the promise that is the subject of the promissory estoppel claim in this case. That promise concerned what Mr. Benning was allowed to build on a secondary, with respect to a secondary structure on his property. That consistent testimony was that then Wyoming State Director Haley Mortimer promised the Bennings that he could build a structure as long as he did not call it a guest house, did not put a kitchen in it, and it was consistent with the Teton County LDRs. Ms. Mortimer has not refuted that testimony. She was the only other participant in this meeting. That is the baseline promise that we have discussed in our briefs. Notwithstanding that, Your Honors, the district court concluded that Mr. Benning, and by implication Mrs. Benning, had simply fabricated this testimony in order to manufacture a claim in this case. The district court, in order to reach that conclusion, made numerous factual inferences against the Bennings, who are the non-movants. There was no evidence that blatantly contradicted the Bennings' testimony, and that type of real contradiction is what would have been required in order for the district court to do what it did and absolutely reject the Bennings' testimony.
Assume that what the Bennings testified about the conversation over that lunch, let's just assume that those statements were made by Ms. Mortimer. As you began your presentation, you said this case has had a long history. How do we view the long history of negotiations, of the exchange of letters, of the litigation with this one lunch meeting in our assessment as to whether or not those statements presented a clear and definite promise?
Thank you, Your Honor. Yes, I think that the history is important because when Ms. Mortimer showed up at the luncheon, she was the brand new state director of Wyoming TNC, and she had recognized, as she said at the luncheon, that she felt sorry about what had happened in the past, that the TNC had been inconsistent with Mr. Benning in the way that it had treated him. She noted that the Wyoming Supreme Court opinion itself noted that the TNC had been inconsistent with Mr. Benning. And Ms. Mortimer said at that luncheon, I don't want there to be any more litigation. I want to solve this, but I need to solve it in the context of the Wyoming Supreme Court opinion. I have to comply with the Wyoming Supreme Court opinion, and I have to find a solution that comports with the Wyoming Supreme Court opinion. She did express regret at what had happened to Mr. Benning in the past and said she wanted there not to be more litigation. And that is what led to her promise. And the promise seems odd unless one really knows the intricacies of the Teton LDRs and of the Wyoming Supreme Court opinion. Because what this really kind of brilliant promise from Ms. Mortimer did was it threaded the needle precisely and allowed her to promise Mr. Benning that he could be within the technical requirements of the Wyoming Supreme Court opinion, still get not all of what he wanted, but a portion of what he wanted, which was that he could have a secondary structure that had multiple purposes, meetings, exercise, whatnot, and also to be, as long as that structure didn't have a kitchen. And that was because the Wyoming Supreme Court opinion focused on what was a residence. And under the Wyoming LDRs, a structure cannot be a residence or a dwelling unless it has a full kitchen. And then again, they get into some pretty nitty-gritty detail talking about a stove. It has to have a hookup, could be natural gas. If it's voltage, it's got to be 220 volts.
To cut you off, I apologize, but at that point, Mr. Benning, of course, also knows that he has been to the Wyoming Supreme Court and lost, and that his communications with the Nature Conservancy have been, more formal. There have been, again, letters authored by counsel. And as you just said, Ms. Mortimer, she's new to all of this. And she came in, as I understand it, seeking to avoid litigation. And so Mr. Benning has this conversation, he walks away. How can we conclude that at that point, it was reasonable to rely upon what was, he deemed a clear and definite promise, when thereafter, they don't just start building immediately. And more importantly, he is insistent that everything needs to be done in writing as to this promise, which makes sense because he's been litigating against them on this very issue for years.
Well, starting at the beginning, how we know that it's a clear and definite promise is that the promise itself had every single term that the architects needed, and they knew exactly what they were able to design.
But what about the fact that Ms. Mortimer, everyone agrees that at the end of it, she said, yeah, I need to take this. He wanted it in writing. And she said, yeah, I got to take this back to my legal counsel. I got to take this back to my staff. I got to talk to them about it. That all by itself says this is not a clear and definite promise. This is something we've talked about, but we're still in the negotiation stage. I'm not done. I, of course, have to take this to my legal counsel. What about that says, oh, we're done. I can go forward on this because I got a clear promise. Oh, and he also said, yes, I want it in writing. And then it never put into writing, and he doesn't push on that.
Yes, Your Honor.
And what is put in writing is nothing about what they talked about, and he doesn't push on that. All of these facts would lead any reasonable person to believe there was certainly no clear and definite. There might have been a clear one, but it wasn't definite.
So
She said, I got to talk to my legal counsel. And he said, we need to put this in writing. And that didn't happen.
Thank you, Your Honor, and I think this is the central issue and a very important issue. And it only works if we refuse to make the inference in favor of Mr. Benning as we're required to at this phase of the proceeding.
Says, but you can't change the facts, which are undisputed, which is she said, I still got to talk to my legal counsel. I'm not, basically, we're not done.
She needed to talk to her legal counsel about the attempted compromise, not about the baseline promise. So I think that
Is that disputed?
it is absolutely disputed.
What she said she needed to talk, did she say, we got a done deal here, I'm just going to talk to my legal counsel for what purpose?
Your Honor, she was going to talk to her legal counsel only in the context of the attempted compromise, which was to get more than the baseline promise. The baseline promise is clear on its terms when they're talking about what more, do I have to talk to other people about it, should we have a writing? All of that concerns another promise, a second promise that never came to fruition.
Oh, she was solid on the baseline promise.
On the baseline promise,
Okay.
that is the testimony
And then
that,
he said, I want whatever we agreed to be in writing, and that never happened. And in fact, something else gets put into writing, and he doesn't say, hey, that's not the baseline promise. That's not what we agreed to.
the interesting thing about that, when it comes out, and it comes out in the form of a writing, September 11, 2020 letter, and what it starts with is that it says, we understand that you want to have 2 residences. And what that means under the very specific facts of this case is we understand that you want to have 2 kitchens. So we know right there that what they're talking about is not the baseline promise. They're talking about the something more, the something that never came to fruition. How else do we know? Because when Mr. Benning was talking about, why are you continuing to negotiate with Ms. Mortimer if you had already the baseline promise that you wanted? He said, boy, I really wanted to get a kitchen. So all of these additional discussions, the things that she needed to take back to her team, all of these other issues involve a completely separate discussion, which is what would have to happen in order for Mr. Benning also to get a kitchen.
No negotiation of the details of whatever the agreement is eventually going to be. That's not, oh, we have an agreement and we're going to move forward with this. It's we have this baseline, as you say, but we don't accept this baseline. I'm going to keep trying to get more. That's not a definite agreement. We're not done negotiating yet.
Well, Mr. Benning did have a clear and definite agreement that he could do at least the minimum. He could at least have a structure, which was an unattached structure that didn't have a kitchen in it, as long as he didn't call it a guest house and it complied with the LDRs. That was what it was. And this would have been a much more simple case if there weren't additional discussions involving the more that Mr. Benning really wanted, which was for there to also be a full kitchen in it. So this was, unlike the cases cited in the briefs, in TNC's briefs, this is very much unlike the Woodward case, in which it's a continuing negotiation with respect to one promise, and there's an expectation of a writing. It needs to be in writing. There's an integration clause even saying that prior oral discussions are invalidated. This is not that case. This is a case in which there was a baseline promise, clear and definite when made. How do we know? In all of the thousands of pages of email communications with the architects, never once is anyone at all ambivalent about what it is that they're building. They know exactly what it is that they're building. And there's even specific reference to the promise at the point in time that Mr. Benning, in October of 2022, puts the plans in. Immediately before, he refers to this promise in an email to his architect, John Carney, and he says, well, I don't think that we should give the plans to TNC in advance, even if we don't have to, and I don't think there's going to be a problem because remember what the state director said to us in the directive that she gave to us. And then replete in the record, which the district court entirely ignored, were numerous emails in which the architects talk about, well, we have to put no kitchen in it to comply with TNC. They're talking about the promise. They're talking about the baseline promise. Everybody is clear what they're designing. It is clear and definite when made, and everybody proceeded exactly on that basis.
Does the record also show that after that lunch meeting that Mr. Benning instructed his architects and their crew to pause work?
He was pausing work, yes, Your Honor. He did pause work as he was contemplating whether or not he could get the kitchen, and that is the purpose for pausing. And 10 days after the conversation with Ms. Mortimer, he was back on track in designing a wellness center, not called a guest house, without a kitchen in it. With that, I'd love to reserve, and I'm sorry that I didn't say that at the beginning.
May it please the court. Counsel, Leah Schwartz on behalf of the Nature Conservancy. This appeal involves the summary judgment disposition of just one claim about a single promise allegedly made over lunch. Considering the legal context, what was allegedly said at the lunch, the written follow-up, and what the Bennings did after, the claim was properly disposed of on summary judgment. This appeal does not involve questions of credibility or he said, she said, and that's because even if we accept everything that the Bennings say occurred at the lunch as true, this claim still fails under well-established Wyoming law, and it fails at every element. I would like to spend a little time at the beginning just talking about the context that Justice Federico mentioned at the outset. The cases say that this context necessarily informs the first two elements of a promissory estoppel claim. What could the alleged promisor reasonably expect by their words, and what could the hearer, the alleged promisee, reasonably do in reliance on them? The Davis v. Davis case is instructive. It says the nature of the transaction is significant. What's at stake is significant. Roth v. First Security, that case discusses the sophistication of the parties and how, when the conversation occurs and how in their course of conduct in dealings with each other. In both of those cases, the promissory estoppel claims were dismissed on summary judgment. So here we have a conservation easement governing the relationship between these parties. This Wyoming Supreme Court does a good job, Your Honors, of explaining what a conservation easement is. I think it's important to just touch on the fact that it is not like a business contract where we might expect people to sit around at a table and haggle over terms, maybe change them. This is a real property interest. It's a perpetual real property interest. The courts have described it as quasi-contractual in nature in terms of how it's interpreted, but commentators also describe conservation easements as a charitable trust. And that's because when they are granted, they serve a public good, a conservation purpose. They are subsidized by the public in the form of the tax write-off that the grantor receives at the outset and in the form of reduced property taxes throughout the duration of the property. TNC is not a party to the conservation easement in the same way we think of parties to a contract. It is a holder of the conservation easement that has certain obligations to uphold and enforce its terms consistent with the intent of the settler or the grantor. In this case, that was Gladys Moulton, a longtime, old-time Wyoming rancher and conservationist in the Jackson Hole Valley. So these obligations set the framework for what we're talking about here. Commentators have described the obligations of a land trust as fiduciary in nature in this context. The Wyoming Supreme Court says conservation easements should be protected against expedient exemptions which defeat the purpose of preserving land in its natural state. We also have the prior litigation here. So we have a Supreme Court opinion interpreting this conservation easement. The court can read what this court can read what the Wyoming Supreme Court said, just as Mr.
Well, then
Binning
you do
and
have
his
that,
lawyers
but
could.
then you have Miss Mortimer seemingly almost trying to go around the Wyoming Supreme Court's opinion to make something work. Necessary for her to do, but that did seem to be the nature of the lunchtime meeting. Was, well, yeah, we're kind of stuck now. You got this you have this litigation, and this was the result, and they said no, so, where to now?
Where to now? That's right. The allegations describe the lunch as a discussion of possibilities, that the detached kitchenless structure, quote-unquote promise, was a concept. So that was the framework. But prior to that lunch, Mr. Binning had received multiple letters from TNC, in-house counsel, Ms. Mortimer herself, saying, we cannot approve a guest house on this property. We are compelled by law to adhere to the Wyoming Supreme Court's decision. This was reiterated at lunch according to Mr. Binning's own testimony, so we can think about the Wyoming Supreme Court opinion in a way as an additional condition or term of the promise in this case. He testified, what she was concerned about was that TNC complied with the Supreme Court ruling, which says you can't have a guest house. She was very emphatic that, we needed to comply with the Supreme Court ruling. That's at R1763. So that is a part of the framework for the parties' discussion. We also know that there was an ongoing dispute about the litigation. This was not okay, case closed, let's move forward, everyone wash our hands here. This was Mr. Binning testifying that he was contemplating renewed litigation against TNC before the parties even sat down to that table.
That important for the context. If Mr. Binning walks away from that lunch and he knows that he's essentially threatened to sue again, and Ms. Mortimer, my understanding is the relatively new president of TNC in Wyoming, and she comes to lunch and says, we want to end hostilities, right? And we want to avoid litigation, so let's figure out a way to get around it. I mean, doesn't that context matter too, and kind of at least lean towards Ms. Binning saying, well, that was her intent for coming to lunch, and she's told me how I can do it. And your opposing counsel just said that Ms. Mortimer was solid on that baseline promise. Why couldn't he rely on that?
Well, because, Your Honors, he read the Wyoming Supreme Court decision. He had access to the conservation easement. He also testified, contrary to the argument of counsel, that he did not trust TNC to honor its commitments, even as of August of 2020. Counsel during Mr. Binning's deposition put him under questioning for some period of time, tried to clarify that, didn't this feeling of wanting to sue change after you talked to Ms. Mortimer? But he testified he was always prepared for litigation against the Nature Conservancy. We, of course, reject the Binning's characterization of TNC's behavior and why he was distrustful of the organization, but the point is there was a standing dispute going into that lunch and a significant disagreement about the legal baseline from which the parties were operating.
But they say that the two, Mr. and Mrs. Binning, say there was this agreement, this baseline agreement. And does Ms. Mortimer say she didn't basically suggest this workaround of the Supreme Court, which is how I viewed it.
She was never asked that during her deposition, Your Honor. So she did not directly.
Nothing to controvert.
Correct.
There's nothing to controvert that there was a baseline agreement.
Well, the testimony did not, this notion of a baseline agreement that only emerges in the parties' briefing. The discussion, the testimony was about a discussion of options. And, you know, the stakes were high at this juncture. The parties had spent a lot of time and money on the prior litigation. The stakes were high for the organization for some of the reasons I mentioned: organizational integrity, upholding the law, and the judicially determined intent of the easement grantor. But the stakes for the Binnings were high too, because they say they really wanted a structure for their guests. That was vital to them. And so we need clarity around that term that is so vital. The court recognized that in the Brown v. Maccabees case, this court, that when a term is so vital, you need that to be adequately described. The claim in this case is for over $11 million in damages because this structure was so important to them. They said they couldn't build any part of their plan without it. So that's the kind of clarity we need. This is high stakes. He testified also that he was thinking of selling his adjacent property, Ranch 10, so he wanted something to show a future buyer, to say this is what you can build, in addition or to supplement the conservation easement, which is in the land records. So it is undisputed that this was a sophisticated businessman looking to preserve his optionality. He had lawyers in the wings. And again, this was a discussion of options. This frames the discussion. But even if we were to ignore all that, Your Honors, and just look myopically at what was allegedly said at the lunch, this claim fails for lack of clarity and it fails for lack of finality, which are two very important elements and, you know, discussed at length in Wyoming case law. Talking about the follow-up writing, there's been, again, argument of counsel. This is argument of counsel, not evidence, but argument of counsel that, oh, well, all he was really expecting or wanting was a written commitment as to one of the options, and further follow-up as to one of the options, but the actual promise did not require written follow-up among the options discussed. Well, the testimony, as Judge Moritz has referred to, was that Mr. Binning actually wanted whatever she agreed to at the meeting in writing. That, Your Honors, is at R1761. Also, R1788. I wanted something in writing that if we decide to sell Ranch 10, we had certainty. You can build this, whatever this is. Record 1789. Question to the witness, but whatever the position was, you needed it in writing to give you clarity as to both structures, correct? Response, we would like a writing because that makes it clear.
Counsel, in terms of the record, did the district court determine that the really only promise that was made was a letter of September 11th that was clear and definite? And do you agree with that finding?
It's an interesting question, Your Honor. Of course, that wasn't actually the issue before us on summary judgment. We note that the letter that's copied in our brief, which counsel actually misrepresents, it does not reference a desire for two residences at all. It's set forth on page 12 of our brief. But that letter expressly states that even the approval of one structure, again, this is just for one structure. So this wouldn't even implicate the associated improvements question, which had been so hotly litigated all the way up to the Wyoming Supreme Court. Even that would be subject to a review of plans. And the Nature Conservancy announced, we believe it's required under the conservation easement that you submit plans to us. It's undisputed that there were no specific plans discussed at the lunch. It's undisputed the term wellness center was not discussed at the lunch. This again was in the context of possibilities, need for follow-up advice. That's at record 1772. Mr. Binning's own words, she needed some advice. He recognized that. I would also point your honors to the follow-up email correspondence around this issue because it is just really overwhelming on this point. R3121, talking about thinking about possibilities and next steps. It was so nice to meet you. Record 2036, we're still working on the letter you have requested. Record 2038, key members of our council are not available this week to review the draft letter. Record 2040, from Mr. Binning, should we still expect a letter? Response, we just finished another round of discussions. So in the same way that in cases like Burt v. Wells Fargo and the Black Card case, the promise was described as precatory, it was not final or firm in this case either. When the letter did finally come, Your Honors, I would also note that the transmittal email is titled, subject, clarification letter. That's at R2043. So whatever Mr. Binning may have heard at the Pines lunch, this letter objectively communicated he and the Nature Conservancy were not on the same page about what he was proposing to build. The Woodward case is on point. While that case did involve a subsequent contract, Judge Johnson in that case observed that didn't much matter. What matters is that the plaintiff saw the writing did not match the terms of the agreement. They suffered a financial loss, but not due to reasonable reliance. Your Honors, I'm nearly out of time, but I would also just point the court to the many conditions attached to this promise. You know, comply with the Wyoming Supreme Court opinion, comply with the LDRs. It can't have a kitchen. Oh, but we must imply that it can't have a kitchen under a technical definition that was undisputedly not discussed at the meeting. The testimony was that no specific LDR sections or definitions were discussed. That is our R1763. And the promise on top of all of that evolved dramatically over the course of the case. The initial complaint discussed a 2,500 square foot structure, and that was undisputed and set out in our statement of material facts in the case. And yet what we see submitted is a 2,700 square foot structure. Again, Your Honors, many bases to affirm. We respectfully ask the court to do that. This is just the type of case Rule 56 is designed to see disposed of on summary judgment. If there are no further questions, I can sit down. Thank you very much.
Rebuttal? Can you add 50 seconds to her rebuttal? I'm sorry, I'm looking over here, sorry. Amy, can you add 50 seconds?
Thank you, Your Honors. So clarity and finality, here's what Mr. and Mrs. Binning testified that the promise was. Go ahead and build it. Just don't call it a guest house, don't put a kitchen in it, and make sure that it complies with the LDRs. That is a promise that was complete, and it was complete when made, and it provided all of the direction that the architects needed in order to do exactly.
If that was the promise, and that's what, of course, you're saying he and Mrs. Binning alleged, wouldn't you think that when this letter was sent in September by the Nature Conservancy, talking about something entirely different, which was a residential structure that consists of separate wings connected in the same manner, that's not the baseline promise anymore, is it?
That is not the baseline promise, and I'm glad you asked, Your Honor, and I'm glad you added the
And then
residence,
this gets
residential.
It gets presented to your
Residential.
client. Yeah.
That's a residential structure, and I think that that's so important, the word residential, because
My question is, instead of saying, this isn't the baseline promise, why are you now saying that this is what we might agree to? He takes a pen and suggests some corrections to it, and he doesn't edit that out.
Your Honor, he wants a kitchen. The reason...
That's not my question. I know he wants a kitchen. I'm saying, if what you have been saying is the absolute fact that there was a baseline promise that nobody's ever going back on, when she writes a letter and puts it in writing, which he's been wanting, here's what we're willing to do, here's the new deal. He doesn't say, oh, no, that's not the baseline promise. In fact, it's different. He makes little edits, which she doesn't accept, but the point being, never, ever again is this baseline promise referred to, and apparently it wasn't called that at the time, but do you see what I'm saying?
I do see what you're saying, Your Honor, and it is in
About the
the,
kitchen, I'm not asking about what he wants, I'm asking about his actions in response to the writing that he wanted.
and I think that the question of whether or not he didn't demand a more specific writing, I think this is an excellent fact question, but it is a fact question and not the type of thing that should be resolved on summary judgment.
No, because the question is, was there a clear and definite agreement? And the fact that he responded by not talking about the clear and definite agreement is evidence there was no clear and definite agreement.
However, the clear and definite agreement, that what was being discussed was a separate attempt for a different agreement, which would have gotten him the ability to have a kitchen. I think that an important aspect of this residence dwelling kitchen component is that for something to be a dwelling or a residence under Wyoming Supreme Court law, it has to have a kitchen. And so why there didn't need to be a writing for the baseline promise is because with respect to the baseline promise, Ms. Mortimer was giving him a workaround that didn't have, that he didn't have to, they did not have to vary from the Wyoming Supreme Court opinion, nor they had to vary from the Teton County LDRs. Everything that she said in this technical workaround that she provided in order to avoid additional litigation was permitted under the law, was permitted under the regulations. What he was asking for with a separate writing that was the September 11 writing was for something plus, something more. And for that, there would needed to have been a writing because that would have been a variation from the Wyoming Supreme Court opinion. When Ms. Mortimer, go ahead, please.
If I understand you correctly, you're saying that because Ms. Mortimer invoked the LDRs, that your client had sufficient clarity to move forward. How are the LDRs even relevant when the Wyoming Supreme Court specifically said that's not the interpretation of the easement, and they did not rely on them, and they interpreted the easement differently?
The Wyoming Supreme Court opinion said you can only have one residence. You can't have more than one residence. And so but under the LDRs, in order for something to be a residence, it has to have a full kitchen. And so what Mr. Binning designed, when his architects designed a wellness center that didn't have a full kitchen, that was fully compliant with the Wyoming Supreme Court opinion, and indeed was approved by Teton County as a structure that was not a dwelling and not a residence.
So you would not agree that the Wyoming Supreme Court opinion and the LDRs are in tension with one another?
I don't think that they are in tension with one another, no, Your Honor. I think that the LDRs inform the Wyoming Supreme Court's discussion, which is that you can have one dwelling, you can have one residence, you can't have two. Well, what makes something a dwelling or a residence? It's whether or not it has a kitchen. And of course, this is a hyper-technical reading, but you know, it's Ms. Mortimer's hyper-technical reading. It was not Mr. Binning's hyper-technical reading. And I submit that she provided this hyper-technical reading of what you can do because she wanted to avoid exactly a situation in which we're standing here litigating more. She told him what he could do to thread the needle very technically and comply with the Wyoming Supreme Court opinion, not run afoul of that, not need to
Counsel,
consult anyone.
you're out of time. Is there any further questions?
Okay, thank you.
Both for your arguments. They've been very helpful. The case will be submitted and counsel are excused. We'll hear case number 258037 SJH 11 versus Dowbuilt.
Good morning, Your Honors. May it please the Court. My name is Ben Petrie. I'm here on behalf of Dowbuilt. I respectfully request to reserve 2 minutes for rebuttal, but I'll keep my eye on the clock. This appeal primarily turns on a narrow but critical error by the District Court. The District Court denied Dowbuilt's motion to compel arbitration on the premise that the arbitrator had already decided arbitrability of SJH's claims against Dowbuilt. He did not. That's clear on the face of the order as well as the record, and even more apparent when you view everything in context leading up to that. The arbitration had been pending for over a year, and the two-week final hearing was just weeks away when SJH filed a series of motions and an amended counterclaim. The Rule 9 motion, which attempted to carve out certain claims against Dowbuilt, Inc., was filed less than 2 months before the final hearing. And when that was rejected, SJH filed an amended counterclaim in which Dowbuilt was named as a third-party defendant. Both of those were rejected on the grounds that they were untimely and as a matter of case management. In rejecting those, the arbitrator noted a couple critical facts. One, well, critical concessions, I should say, on behalf of SJH. One, that the parties had always viewed Dowbuilt and SDI as interchangeable. And two, that SJH had confirmed that it was already pursuing counterclaims against Dowbuilt based upon its original counterclaims filed on February 27th, 2024. On SJH's motion for clarification on striking the amended counterclaims, the arbitrator ordered that SJH could pursue its original counterclaims submitted on February 27th, 2024, and proceed against both entities. And it only clarified that SJH was not required to pursue its new counterclaims in that arbitration. That phrase in that order on the motion for clarification is absolutely critical because it shows that he was not deciding arbitrability completely. He wasn't deciding arbitrability at all. All he was saying was, as a procedural matter, they could not pursue those counterclaims in this arbitration.
But counsel, on the original orders, I think in the Rule 9 to pursue the counterclaims, let's say there's some ambiguity though as to the orders, whether or not the arbitrator was actually issuing a ruling as to arbitrability. Why doesn't the last order regarding the motion for clarification sort of settle this? You said, you started by saying it's clear on its face that there is not a decision as to arbitrability. I have it in front of me, and I don't see here where the arbitrator is saying I'm not making such a ruling. In fact, a fair rating may be quite the opposite. So help me understand how it's clear on its face from this order that the arbitrator is not making a determination on arbitrability.
Yeah, the arbitrator, there was no analysis of arbitrability because it wasn't brought before the arbitrator on that motion for clarification. The district court made the error of focusing on really two sentences in that order. One was in the second paragraph of that order, in which he simply made the observation that there was no agreement between SJH and Dowbuilt, Inc. And then on the last one, the last sentence, is the reference to they can go ahead and pursue a claim in a court of competent jurisdiction. But what you have to do is that third paragraph is critical to this analysis. That third paragraph, the arbitrator wrote, while allowing the February 27th, 2024 counterclaims to proceed against both SDI, LLC, and Dowbuilt, he was acknowledging that in the hearing that at that point was 2 weeks from the date of that order, right? Because that was issued on January 17th. We were scheduled to go to the 2-week final hearing on February 3rd. So he's saying in that, that I'm allowing them to proceed against both well, they were counterclaims, right? But against both SDI and Dowbuilt.
Wasn't allowing them to proceed on all their counterclaims. Isn't that the problem? As I understand it, they said we want to bring these counterclaims now against Dowbuilt. We now have understanding that they are different from SDI. And the arbitrator said, no, you can't do that. And so we're 2 weeks out from arbitration. It may make sense I'll allow you to go forward on your original claims and those that maybe use those two entities interchangeably. But you can't do that now on these counterclaims you brought against Dowbuilt. And those tend to be separate. So.
Right, that goes back to that critical phrase, in this arbitration, because he could not allow them to pursue those counterclaims in that arbitration because we were going to hearing in 2 weeks.
Those counterclaims, you can't pursue them here. You know where you need to do it? A court of competent jurisdiction.
But in doing so, he made no ruling as to arbitrability because we can file a motion to compel once they file a separate case. And in fact, so that was decided on January 17th.
Well, didn't the court say, it said, it doesn't mandate, you know, the existing counterclaims against Dowbuilt does not mandate that SJS is forced to arbitrate its other claims against Dowbuilt in this arbitration.
So
What does that mean?
Yeah, right.
Isn't
So
that clear, though?
Yeah,
I
no.
mean, I think it is clear.
Well, so what is it in that sentence? It is him allowing them to pursue the claims and move forward with claims against both SGH and Dowbuilt in the upcoming hearing in 2 weeks, right? So,
Anything else is not arbitrable.
no, that's, so let's actually look at that paragraph as a whole.
It doesn't mandate that they're forced to arbitrate their other claims against Dowbuilt in this arbitration, period.
Right, in this arbitration. He's not precluding arbitration completely. He's not ruling that it's not, they can't be subject to arbitration. He's saying you can't rule it in this arbitration. And to understand, to even put more context, that was issued on January 17th. On January 19th, they filed their complaint in district court. On January 21st, the parties stipulated to vacating the hearing and staying the arbitration. And the arbitrator granted that. If he had determined arbitrability, why would he have ever granted a motion to vacate the hearing and stay the arbitration? And I apologize that that order is not in the record, and I take responsibility for that. But I do address it in my declaration, because what he said was, what we discussed was, we're going to file a motion to compel in district court based upon this complaint. And so we are asking, in order that we don't have parallel pieces of arbitration litigation moving forward, we're going to ask that we stay this matter. SJH agreed to that. If SJH had thought that arbitrability.
At all, you know, about, maybe because we don't have the order, I may be missing this, but the parties go to the arbitrator and say, well, there's now these claims filed in district court, and we're gonna litigate whether or not they're gonna proceed in that court. So we wanna stay this arbitration. We don't want parallel proceedings. And the arbitrator is saying, if you both, if that's what you're asking me, sure, let's stay it. How does that inform our analysis here?
Because why would he stay? Why would he vacate the hearing and stay the proceeding?
Because the parties asked him to.
But if he had already determined arbitrability, I think he would have said, I've already determined they're not arbitrable.
There's this group of claims here against SDI and Dowbuilt, and that's what he's staying, right? So he's not talking at all about these other claims that are now in district court. I guess that's what I'm not tracking on.
Well, no, because he said in his order, he said, I understand that if the motion to compel is granted, then we're going to consolidate these actions and move forward together. So, I mean, he anticipated that the motion to compel, you know, he anticipated that being granted and the parties proceeding in one arbitration.
Okay, again, I haven't read the order. That seems maybe like a stretch of a reading to say, well, I'm going to get out ahead of the U.S. District Judge and say that motion to compel is going to be granted. And then when it is, it'd be more efficient for us to hear all these claims together. I mean, it would just make sense to me if you're an arbitrator and the parties come to you and say, we want to stay it so that we can go litigate over here. And we don't, you know, that the arbitrator would say, well, I don't know what the district judge is going to decide, but sure, if that's what you're asking me to do, that seems like a, you know, plausible, reasonable position.
I stand on my, you know, on the argument that it wouldn't make any sense if he knew that he had already decided arbitrability to go ahead and proceed. We would have gone forward with the hearing 2 weeks from there. And that's the thing, the context in which this all happened, I think is important to keep in mind as you're reading the arbitrator's order.
Counsel, let me ask you about that. What entitles or subjects your client to the opportunity at arbitration in this context?
Well, there's a concession that they already have claims against Dowbuilt, that they're pursuing those in the arbitration.
There's a concession by whom?
By SGH.
There's a concession by them that they have claims against Dowbuilt.
That they are actively pursuing counterclaims against Dowbuilt in the pending arbitration.
Right.
The one that is currently stayed. There's also the concession that they've treated the parties interchangeably.
Last sentence of that clarification order, and I don't think I read that earlier, the last sentence is, the arbitrator ordered that the SJH retains its rights to pursue claims against Dowbuilt that were not brought in its February 27, 2024 counterclaim in a court of competent jurisdiction. Why doesn't that answer the question?
He's responding, the motion for clarification did not address arbitrability at all. It said, Mr. Arbitrator, we want confirmation that our claims are not precluded moving forward, and two, that we get to pursue these elsewhere. That's what the motion for clarification requested. So he was simply responding to that. Arbitrability was never addressed in the motion for clarification.
To follow up to my question, you talk about the fact that there had been some counterclaims and proceedings in this arbitration that involved your client. Your client was never formally joined as a party to the arbitration, isn't that right?
It was not named, but that goes back to SJH's concession that they were treating the parties interchangeably.
And what is the evidence of their concession?
Well, they stated that during the hearing, and the arbitrator took note of that in the Rule 9, on the order on the Rule 9 motion. The Rule 9 motion was filed, there was a hearing shortly thereafter, and during that hearing, they conceded that they viewed the parties as interchangeable, and that they were already pursuing counterclaims against Dowbuilt, Inc. And my friends on the other side have made the argument, well, you know, we just learned of Dowbuilt, Inc. in December of 2024. But I would point the court to the record, page 530 in the record, in which they explain in 2023 the understanding of the relationship between Dowbuilt and SDI. And that goes to that concept of them treating them interchangeably. It started before the project even started. They treated them as interchangeable throughout the entire course of the construction project, as well as through the arbitration. I see I have 2 minutes left. I'd like to reserve that for rebuttal, please.
May it please the court, William Adams for SJH, the owner of the properties in the underlying dispute. Arbitrability was both submitted to the arbitrator and resolved by the arbitrator. To determine the submission issue, you need to look no further than Dowbuilt's own submission to the arbitrator. If you look at pages 468 to 469, which is their opposition to the motion to clarify, it's actually identical to the lead argument that Dowbuilt makes to the district court in seeking to compel arbitration. So they presented arbitrability, SJH did too, and I'll get to that in a moment, but they joined issue with SJH on the arbitrability issue. At page 468 of the record, Dowbuilt says, SJH's proposed claims against Dowbuilt, Inc. are clearly within the scope of the contract's arbitration provision. This provision clearly encompasses SJH's proposed claims against Dowbuilt, Inc. as a matter of Wyoming law. It then continues to discuss Wyoming case law, including the Jackson State Bank case, which the arbitrator then distinguishes in the clarification order. This submission was not just by SDI, it was by Dowbuilt, Inc., which had injected itself into the arbitration. We know that at page A460 and A472, where counsel is saying that the argument is on behalf of Dowbuilt, Inc. SJH likewise raised the issue of arbitrability. This whole process started with the Rule 9 motion, where my client was trying to get confirmation that these tort claims against Dowbuilt, Inc. were not part of the arbitration, were not arbitrable, and could be brought in a court of competent jurisdiction. The Rule 9 motion is at page 376 of the record, and SJH repeats these arguments in seeking clarification. In fact, Dowbuilt says that the clarification motion is just a motion for reconsideration of the original Rule 9 motion. They say that at page A46, so A464 of the record. So we have SJH raising arbitrability, Dowbuilt, Inc. joining issue on the issue of arbitrability, and then we get to the clarification order. That's the key to the appeal. and that is on page A267. And
Clarification about, was it arbitrability or was it, hey, we have these counterclaims, you said they're untimely?
It was that it could pursue the claims, the non-contract claims against Dowbuilt, Inc. in a court of competent jurisdiction. That is an issue of arbitrability, certainly, and then the arbitrator decides that issue. The arbitrator has 4 key rulings on page A267. We talked about 2 of them earlier, but I'll go through all 4 of them with the court's indulgence. The first thing that the arbitrator says is there is no evidence that has been presented that Dowbuilt, Inc. was a party to an arbitration agreement with SJH. That's about arbitrability. The second thing the arbitrator says is that there is no arbitration agreement between Dowbuilt, Inc. and SJH. The third thing, which is in the paragraph you spent a lot of time in colloquy with my friend on the other side about, that says that SJH's existing contract claims do not mandate that SJH is forced to arbitrate in its other claims against Dowbuilt, Inc. in this arbitration or be precluded from bringing them, asserting those claims at all. That implicates arbitration and arbitrability and the scope of that particular arbitration. And then the fourth and final thing, he cashes it out in the final paragraph, and he says, just as SJH requested, SJH retains its right to pursue claims against Dowbuilt, Inc. that were not brought in its February 27, 2004 counterclaims in a court of competent jurisdiction. That's a ruling on arbitrability. And that ruling was for the arbitrator to make. There's no dispute that there is a clear and unmistakable delegation of the arbitrability issue to the arbitrators in the contract in which Dowbuilt is trying to invoke. They incorporate the AAA rules. This court has been very clear in Gold Group, Dish Network, Belknap, that that's a sufficient delegation and via incorporation of the rules. And the only way that this court could set aside the arbitrator's determination of arbitrability was if there was manifest disregard of the law. That's from this court's decision in Dish Network. And Dowbuilt, Inc. doesn't suggest that the arbitrator's determination was a manifest disregard of the law, and of course it was not. And respectfully, we think that's the end of the inquiry. Any other issues of arbitrability, whether it's consent or the equitable estoppel argument, those issues were for the arbitrator, but they didn't raise them, and there's no basis that I'm aware of for the district, for any federal court to be addressing those arbitrability issues. You don't get a second bite at the apple. And so unless there are any further questions from the court.
Counsel, do I have the situation correct that if the district court would have granted the motion to compel arbitration, and the arbitrator's already said you can't bring these counterclaims against Dowbuilt, and that effectively leaves your client without a forum to adjudicate those claims?
I think that's right, and that's what the district court ruled in rejecting the equitable estoppel argument. The arbitrator had concluded that these the non-contract claims were untimely in the context of that arbitration, and he struck them, the arbitrator did. And so to then send it back to the arbitrator who has ruled that these claims don't belong in the arbitration really sets up I'm not sure exactly what would happen then, right? I mean, there's a great uncertainty, and sort of as the district court explained, a great sort of unfairness to my client to be put in that circumstance. But the arbitrator was very clear that they could be pursued in a court of competent jurisdiction, and my client therefore filed its complaint in the district court.
I know you may not want to travel down this path at all, but is equitable estoppel even recognized under Wyoming law in this context?
Your Honor, there is no case from the Wyoming Supreme Court or adopting or considering equitable estoppel in this context. Dowbuilt, Inc. frankly didn't give the tools to this court to predict what the Wyoming Supreme Court would do, and so I don't think that they have carried their burden. Even if you were to get there, of course we don't think you should get there, I don't think they've carried their burden to show that the Wyoming Supreme Court would accept.
Suggesting then that waiver may come into play?
I think it's either a burden or either they didn't satisfy their burden or they waived it by not adequately developing the argument either in the district court or in this court. But again, those are issues that frankly would be for the arbitrator if they had made it to the arbitrator, because equitable estoppel, of course, is an issue of arbitrability. The delegation clause means that it should be for the arbitrator to resolve that issue, but they didn't present it to him, and I respectfully suggest there's no reason for this court to reach that issue. If there are no further questions, we respectfully ask the court to affirm. Thank you.
Your Honor, on the issue of equitable estoppel, we can see that the Wyoming Supreme Court has not addressed that, but obviously the 10th Circuit has. We would ask this court to follow Reeves.
Law.
It is, and we acknowledge that, but that rationale would apply. It's been adopted by numerous circuits, and as explained in Reeves, and we would ask this court to apply the Reeves analysis here. That obviously, equitable estoppel will bar the signatory to an arbitration agreement from avoiding arbitration with a non-signatory. And we focused, as you saw in our briefs, on the second possibility, if plaintiff's claims raise allegations of substantially interdependent and concerted misconduct by both the non-signatory and the signatory to a contract. When you look at their claims in the complaint in the district court, they're all tied to the contract, right? They talk about payment issues. They talk about the use of the money. They talk about the audit, the audit that occurred. All of those are tied to the contract. And for that reason, equitable estoppel should apply. I think it's also important to note that going back to that third paragraph, at the very least, we've asked for a reversal of the denial of the motion to compel. At the very least, I think remanding to the arbitrator to say whether or not he ruled on the issue of arbitrability makes sense under these circumstances. While it hasn't been used in this context, I think remand makes sense because it goes to ambiguity within the order, which I think is evident based upon the discussion that we've had today. And it helps give the parties the benefit of the bargain in terms of entering into a contract with an arbitration agreement. So I see that my time is up, unless the panel has any questions.
Thank you, counsel.
Thank you.
Thanks to both of you. We appreciate your arguments today. They've been helpful, and we will submit the case, and counsel are excused, and the court is till tomorrow morning, 9 o'clock.
Court is in recess.